Yes, we are live. I hope you can hear me. Wave to me if you can hear me. Hope everybody's well. Good evening, good afternoon, good night. Happy day. Happy Wednesday to everybody. Great. Good to see everybody out there. John, Tim, the one, Ben, Gary, etc. I like your question, Gary, by the way. Answer is perhaps for some people. So for today's purposes, what I intend to do is bring you up to date about what happened in today's particular hearing. Who just came in here? Darren. Hello, Darren. So I wanted to bring you up to speed as to what occurred, and it was an interesting time. So before I start that, of course, I wanted to put some context to things, which I will do at first. The hearing today was in Las Vegas. I was on Zoom, although I was in Las Vegas yesterday. Something occurred. I had to come back, so I participated in the hearing on my phone as I was driving back from Las Vegas. So, and while I was in Vegas, as it turns out, I met somebody you guys know very well, JR. JR and I and two other people also interested in GTII had dinner last night. So it was nice to see JR. Greetings to JR, wherever you are. Are you here today, JR? I don't think he knows that we're doing this. Anyway, I'm looking quickly. What do you call an auditor who points out the obvious? An auditor who points out the obvious. Why was the auditor standing on one leg? To ensure proper balance. What do you call an auditor? Excuse me. What do you call an accountant? An accountant with an opinion. An auditor. An auditor is someone who solves a problem you did not know you have and explains it to you in a way you don't understand. And last but not least, I think this is pretty applicable to our situation. Definition of an auditor is someone who arrives after the battle has been lost and bayonets the wounded. So today's hearing in Las Vegas was to find out what was going on with regard to the audit that we've all been waiting to have completed. And there were several attorneys who were present, or at least on Zoom. There were some in the courtroom. In the courtroom was the Receivers Counsel, Candace, who represents some of the plaintiffs, some other attorneys on Zoom. I think the Alex Calloway for plaintiffs' attorneys, attorney for Reichman was there. There may have been some other, there was probably a couple other people. Myself, I was on Zoom. So the way the hearing was, it was set as a prior hearing the last time because of the decision by the auditor to quit. So the court ordered a hearing, and basically an order to show cause hearing to hear what was going on. And the first part of the hearing was talking about, or the witness was the managing partner of the prior CPA firm, Barton, who just quit. And it was Mr. Barton. And this is just my opinion of Mr. Barton. I did not think he was a particularly good witness. If he was doing a promotion to get business, I think he failed. I think he wasn't prepared. I think he had a bad attitude and didn't explain anything. So I don't know if he had looked at anything before his testimony, but for example, when asked about, let me get into some issues. So basically the story is, as we've heard it, the audit's been going on. As to this particular firm, there was a woman who was involved in running the audit from, I think, about January of 2025. September of 2025, she left because she was pregnant and I guess she was delivering. I think they had to put in some additional people to run the audit. it appeared, based upon what the receiver said, they basically started all over. And the reason why the receiver said that was because they asked him for documents that had been already produced, and they seemed to be going over the new territory. Anyway, so that's about September, October. New people come in for audit, and we take us up to April, and that's when they stop doing anything. They quit, basically, before the last hearing. Through the testimony that was provided, apparently the receiver, based upon his communications with the prior auditor who left in September or took leave in September, he was expecting the audit to be completed in that time frame, and he testified to the fact that he contacted his guy at Edgar to get the 10K ready to prepare, and that was in August of 2024. So we're like many months thereafter. But after August, September, the main auditor left. So, and that's not Mr. Barton, the gentleman, and I'm using that term nicely, the gentleman who testified today and offered nothing of substance, no explanation, in a very unprepared or prepared fashion, depending on how you want to take it. So Mr. Siciliano, the attorney for receiver, questioned him for quite some time, asking about interactions between the receiver and the auditor. And the issue was, what it comes down to is there was some transactions, and this is based upon what Mr. Barton said and kind of substantiated in part by the receiver. There were some transactions, or the way things were set up, that were not supported, and there were a bunch of questionable transactions. And it ended up the auditor wasn't willing to sign off on the audit unless a third party, unless certain information was provided, or hire a third party to work with this auditor to get rid of or provide substantiation or backup for certain items. So apparently, before that happened, before there was a third party brought in, the receiver and his forensic accountant basically redid the financials to try to comply with what the auditor said were the deficiencies. So the auditor says you have X, Y, and Z's wrong, and per the testimony of the receiver, what they did is he and his forensic accountant, they basically put together new financials following what the Barton gentleman wanted, and they resubmitted them. The receiver believes that Barton never looked at the resubmission, and in part, they say that because they got a letter from Barton, and I don't know if it's specifically from the gentleman who testified today or Barton CPA. When I refer to Barton, it refers to the name of the company. It's not just the name. But there was a discrepancy in the testimony today talking about that they weren't willing to go forward because they couldn't get backup. But there was also a letter apparently that was sent in by Barton that basically said, and this is not today, this is back to the last hearing, but it was discussed today. So Barton says, there were certain deficiencies, they weren't able to correct it, and that's why we stopped. But there's a letter apparently where they offered to continue their services, notwithstanding that, as long as they were paid on an hourly. So they wanted to change, apparently they wanted to change the terms of the engagement. And then before anything else happened, they quit. And that was the last hearing. Now, Mr. Barton was questioned as to what the shortcomings were in the information, and he acknowledged that the receiver had provided them information, and the receiver testified that basically they provided them everything from the start, including what I guess Fortune, the prior auditor, had done. But when questioned about specifics about what the items that were in question were, Mr. Barton had no clue and didn't offer any. He said he didn't know. And if he didn't know, he didn't look. And obviously, somebody who's going to testify about a particular subject matter, this is just my opinion, somebody's testifying about a particular subject matter and they want to be upfront, transparent about it, they will look at the materials before they testify so that they could deal with all the issues and so they don't make mistakes. And that's the way somebody who really wanted to present testimony that was transparent and clear, they would prepare for that. And that's how people prepare for depositions. They review materials, etc., so that when they are questioned, they don't look like an idiot because they can't answer basic questions, especially when they're talking about their own company. It makes them look pretty, I don't know. You could draw your own conclusion, but asking somebody about their own business and then they don't know suggests that they probably didn't look. So this gentleman, I don't think was, my opinion, I don't think he really participated in good faith. When he's questioned about specific transactions that the receiver didn't provide information to back up, he wasn't able to identify that. And the receiver was kind of, when he testified, he suggested that he was pretty disappointed because he believed that these guys didn't review the revised financials that they had worked hard on and presented. Instead, they just quit. That's kind of the way the presentation is. And the issues that were described, it comes down to apparently only 5 or 6 issues, could be of a significant dollar amount. But the question was that there wasn't sufficient backup for that. That's at least what Barton says. But again, I didn't find his testimony to be either compelling or trustworthy, to be honest. So I really don't know. In terms of the quality of the work or whether it could be used, and somebody asked whether you can get a refund from these guys. And again, these guys were paid $55,000, which their estimate, and nothing was discussed about this, even though I put it in a brief to the court for whatever reason. I guess the court wasn't interested in this issue, but they were paid $55,000, even though, and this was discussed, their estimate was $175,000, and I don't know, I don't understand that analysis. Still don't understand it. There was no explanation provided for that gap, and again, the court didn't seem to be particularly interested in that question. Just to kind of go back to that issue, the court seems to be more interested in getting things resolved as opposed to attributing blame. So when there was discussion, and I'll get to that in a second, when there was discussion that was kind of off the, and it was very patient. The morning hearing started at 9. It didn't end. And there were some other matters. And then our matter was called and after 11, and it went in the specific time, and it went till about 12:40, I think. So that was into the lunch break of the court. So the court stayed open, didn't take lunch. So he was working hard. But I think his interest is in trying to get a resolution and resolve as opposed to attributing blame. And one of the examples I would state is, so Mr. Siciliano asked a bunch of questions. Then Caroline asked a bunch of questions. And then I asked two questions. I don't think anybody else asked any questions. Yeah, I don't think anybody else asked questions. So I asked 2 questions. One was related to, and I was interested in terms of the issue about, we've had a bunch of reports. I didn't put it like this, but this was the basis of the question. We've received a bunch of reports that says that the audit's almost done. And so I asked the Mr. Barton, did you ever, besides, he had testified during the hearing that in late March, he had given the impression or the specific information that the audit was almost done or substantially done or words to that effect in late March of 2026. So my question was, other than March of 2026, did you ever tell the auditor that, did you ever tell the receiver that it was almost done? And he kind of indicated that he kind of, sort of, he wasn't very specific like the rest of his testimony, but he kind of, sort of said that. And then when the receiver testified, he indicated that besides that, the prior, and I forgot what her name was, but the prior auditor, as of August, had certainly led him to believe that it was going to be imminent. And that's why, and when the receiver testified, that's why he said that he had his guy at Edgar get ready for the 10K in August of 2025, because he was led to believe that we were near the end and it was imminent for it to be done. So trying to think what other things might be of interest. So the refund. Somebody asked me about a refund from Barton. I think it's worthwhile asking. I think they were. I don't think they did the job. I think they should return the funds, and I think there should be some action contemplated against them. But we'll address that in a second, because I don't think they did their job, or certainly didn't complete their job. And but anyway, they said though that their work product, could be helpful to the subsequent auditor. Wasn't clear whether because they apparently redid everything. Wasn't clear, and it was a suggestion if you bring in a new auditor, they can't rely upon the old auditor, so they would have to redo the audit. But the suggestion also by Mr. Barton, and again, I don't really know if this is truthful and it's accurate, but I understand why he would say that, because he wants to not get sued or wants to keep his money. Probably more so the latter. He wants to retain his the fees that were paid. So he testified that there was value that was provided, and the subsequent auditor would be able to kind of step in and use their work product to get much caught up as to the status of what was going on, and that would speed up the process. And even though they couldn't rely specifically on the work product, they could get up to speed more quickly. So question number one I asked was about the whether Mr. Barton had informed the receiver about the status, and it seemed like to be consistent with what the receiver had said in the past. There seemed to have been communications suggesting that. And the second question I asked, and I knew, I think it was after the first question, I annoyed Barton's attorney, because he said, "Who's this guy asking questions?" And then somebody piped in that I was an attorney and I was plaintiff. I wasn't planning on asking questions, and I try not to push beyond what I think will annoy the judge. That's my role here. And I file briefs, so it's in the record. And I don't really know, again, how much consideration the briefs get, but it is what it is. So my second question to this Mr. Barton was, my understanding is you guys, and again, this was my understanding. Nobody has corrected me, and they didn't correct me today. And if it's not accurate, I would appreciate somebody correcting me. But when I did my research, this is what I found. And again, it doesn't mean that Barton CPA aren't great, although wasn't very impressed by their leadership. But what I asked was, I said, there was a late 24, early 25. I saw that apparently your firm had been fined $25,000 for some kind of misconduct related, and was put in by the PCAOB, which is the board that kind of supervises them. And at midstream, as I was asking that question, there was an objection, and then the court sustained the objection. So I got on I annoyed somebody and got on their nerves. And the reason why, the judge sustained the objection. I was going to explain the basis of my question, but again, I'm not trying to rile up the judge. So if he pushes back, unless it's something that's absolutely essential, I'm not going to push back on him. But my thought, I'm just going to say it now so you get it. My thought was, shouldn't you have disclosed that to the receiver? So if you, based on the history of these companies and the auditing trail, the fact that you got disciplined by if in fact that's true, if you got disciplined by the PCAOB at the time you took this engagement, shouldn't you have disclosed that if it actually happened? And the flip side is, if that actually occurred, should the receiver have been aware of that? That was the second part of the question. And then the second part of that same question that I didn't get to ask, but I'll ask here, was I also understood, my research was that in 2025, they also got fined by the Texas, I guess, equivalent for a different thing in $20,000. And again, I was going to ask about that, I was going to ask to see if that was accurate. And then the point beyond that was in 2025. If that happened in 2025, then why didn't the receiver know about that? Just seems like a question that you would, because of the history of the receivership and of the auditing trail, etc. So all that goes on. The hearing was, probably like a testimony, probably for an hour. At the end, the judge kind of wanted to move forward. And so the decision was made, because this auditor obviously is gone. And one, I don't think they would be trustworthy, in my opinion. I don't think they're trustworthy based upon how they presented themselves before and today. But the judge wanted to go on. So the decision was made to select, and apparently the receiver had already gone out, made preliminary contact based upon what happened the last time. And he has two choices and is looking for a third. Apparently has had a contact with them. Apparently there's only like 5 or 6 items, so that these firms apparently can do, we'll see, I'm skeptical, but apparently these firms can do the outstanding audit and the 2025 audit in a reasonably short period of time, apparently. So the idea was to disclose who those firms were, and then next Wednesday, so a week from today, there would be another hearing, and one of them apparently will be selected, and then they'll get going forward. And I'll discuss a problem before we get that. Now, I wanted to, since it came out about 30 minutes ago, the names of these firms, so I wanted to disclose those to you. And if anybody knows about any of these firms and wants to comment about them, if they have a personal knowledge, please let me know. There's only 2 that have been disclosed so far. I think there's going to be a third, but here are the 2 named firms. And again, if you have any good, bad, personal information, just post it on X or something where we can all see it and let us know. So the first name of the first firm, and apparently they're able to go in and they can kind of reconstruct these issues. That's what they can do. Weinberg and Company, which is located in Century City. That's one company. And the other one is called, I don't know how to say it exactly, but I'm going to spell it. INTEGRITAT CPA. So it's like Integrit. So it's kind of like saying integrity. And when somebody says kind of like integrity in their name, kind of makes me think the opposite, but I don't know anything about them. So, but they're based in Boca, Florida. So one's in Century City, which is LA, one's in Boca in Florida. There apparently will be a third one, perhaps, because the receiver mentioned there was a third potential one that he was going to mention. He was going to talk to them, but he hadn't yet. I don't know the name, and I didn't see it in an order before I went on today. Now, here's the problem. Sounds like a problem to me. Apparently and there's activity going on, so monies may come in, but as of right now, there is $10,000 in cash in the bank for GTII. $10,000. Now, the retainers for the CPAs were substantially more than that. So there was definitely push as to how you're going to pay for that. The receiver was kind of not clear, but in the end, he basically suggested that the receivership can borrow money. He didn't say from whom. I don't know who's going to lend money, but apparently the receivership could borrow money. Maybe they'll borrow money directly from the receiver. Maybe the receiver will put up some of his own money, put it out there, and then we'll hire an auditing firm. But he seemed to be somewhat confident that he'd be able to raise the necessary capital to pay the retainer for the next auditor. Now, I don't know if that means he can pay for the entire audit at this point in time, but at least the retainer. Now, in the Barton case, for example, the initial retainer was $27,500. So maybe that's kind of what he's thinking would be the retainer. But the fact that the GTII only has $10,000 in the bank, that's something that got everybody's attention.
which, and I know that they're engaged in trying to secure additional money. And I know one of those, at least my impression is, that Reichman's condo would generate some cash. Now, my guess is also that there is money owed to like the lawyers, whatever, could be substantial amounts of money. So I would think that the receiver would be anxious to get a deal done so money could be brought in so everybody could be paid. Because at some point in time, everybody's going to need to get paid, because I don't think these lawyers are doing this pro bono. Well, other than me, but I don't think anybody else is doing it pro bono, and I don't know how they're going to get paid. And they heard it too. I'm sure they were aware of it. And I think their bill is substantially more than $10,000, and their future bills will be substantially more than that. So either there's money coming into the bankruptcy estate, or there's a bunch of people working for free, however that goes. But it suggests to me, because the attorneys are still working, that they expect money to come in. So I don't know what the source of that money is. I don't know if somebody's selling something like baseball cards. I don't know if there's a transaction in the works which could, fund things. I don't know if there's a lender who's interested. I don't know any of that. But the suggestion is that there'll be the money available to pay the retainer, and that should be known by next Wednesday, I believe. Presuming that the third party, if there is one, and presuming that the hearing goes forward, which I have no reason to doubt. So if next week goes forward and there's someone is chosen, then I would presume that they'll be hired in short time, I would guess, within a week, and they'll begin their task. And I guess these firms, whatever shortcomings Barton said were in the documentation, and it sounds like there was a substantial amount of documentation that was provided to them, but whatever shortcomings there were, and for backup, it seems like these firms would be able to take care of that. And that Barton just wasn't able to offer an opinion unless apparently they got paid more money, seemingly, by their, basically the letter that said, we'll do it if you pay us hourly. So the fact that we only have that much money, does that concern me? Yes. But again, based upon what the receiver needs to do, seems like that, at least for the time being, that the audit portion is taken care of. I don't know about the legal portion. I mean, and I don't think these guys could get out very easily if they wanted to at this point in the case. But I don't know. But it seems like everybody's going forward and everybody's still putting a lot of time in, and we'll have to wait and see about the new auditors. And again, if anybody knows about either of those auditors and has an opinion, post it, let me know, whatever, good or bad, if you had an experience, because it's nice to know, since it doesn't appear to this point in time that the receiver has done a good job at, it may have done a good job at a lot of things, but choosing reliable and transparent auditors, it doesn't seem to be, to me, that doesn't seem to be the case, at least to this point in time. And it may just be the auditors, may have nothing to do with the receiver, but seems to be a lot of problematic auditors. And, our audit trail, just because I like to repeat this, we got Borgers kicked out by the SEC, and apparently there was somebody before Borgers who was also terminated. Then we have Fortune, who they have to fire. Then we have Barton, woman who's going to give birth, who doesn't finish. Then we have a restart. And then they quit. And that's where we are today. Not a great history. I don't think not great management. I think there should be responsibility for management of the situation. I think the court is more concerned about getting things done and is not really interested in attributing responsibility or whatever. He wants to get it done. And I understand from his perspective, he's got a zillion cases. Today, he spent a bunch of time that he probably was more than he really wanted to allocate for this. And he wants to see the process complete, the company complete its audit, the business to start up, and for us to have a chance at getting paid. So that's the sum and substance of what happened today. I'm going to take a quick look at my scribbles. No, that's basically it. So, again, basically Barton testified to the fact that there were certain things they needed that they couldn't get. The receiver testified that they provided that stuff. And then the receiver also testified that he thought that Barton didn't really look at the updated information. And my impression of Mr. Barton wasn't very favorable. So notwithstanding whatever qualms, issues, complaints I've had about the receiver, today I really did not, I was unimpressed with the receiver's choice of this particular auditor. So that brings you up to speed. We'll kind of keep you apprised. When I hear about the third auditor, if I do, I will let you know. There may not be a third auditor. Again, if you have any information as to the two I mentioned, let me or somebody else know, and we will keep you apprised. I know everybody's still working. So as long as everybody's still working, let's keep it up. Thanks for everybody. Have a great day. See you soon, and talk to you all later. Have a great night.